Welcome back to Court TV Live. I'm Michael Ayala.
She had a choice to call 911 and get emergency help personnel to that residence, or she could do what she did, which was perform amateur CPR. She is standing over him with the power to help. She chooses in that moment to let Michael Redlick lead to death.
Breaking news this hour in the kitchen knife murder trial. We are just moments away from the jury in the Danielle Reddick trial getting the case. This after the defendant's daughter returned to the stand today, refuting that her father was a wife-beater. Now, we will break down her testimony just a little bit later in the show, but the state right now is continuing its rebuttal closing argument. So let's get you right back into that courtroom and Prosecutor Sean Wiggins.
Michael didn't punch her, he did this. Why? Because she can't say that she was choked, and she can't say that she was punched because she knows she doesn't have the physical evidence to support that. So she has to construct a story that matches the physical evidence the best that she can. She has to find a way to fit the facts to her story. And then we look at Michael's physical condition. Over and over again, you are told by defense, she only stabbed him one time. And if you just use the word stab very literally, and I guess that's correct. There's stab and there's incised. Danielle Redlick gets on the witness stand, puts her credibility at issue, and she takes this opportunity to tell you why she killed Michael Redlick, and she gives you play-by-play, everything that happened. And she knows those injuries are there. She knows that his eye is cut with a knife and his side is cut with a knife. Defense counsel knows his eye is cut with a knife and his side is cut with a knife. And she has not asked a single question about that. Not a single solitary question about how Michael gets cut in the eye and how Michael gets cut on the side. Whoa. Not a word out of her mouth that accounts for two other occasions where she takes that knife and she reaches it out and she cuts Michael. She cuts Michael in the face, she cuts Michael on the side, and she stabs Michael. And where did you hear that from? Nowhere. Why? Why? Play by play, every nitty-gritty detail of what she did to save her own life. And she says nary a word about the two other times that she used a knife on Michael. Defense counsel gets up an opening, and through this entire case, and it's like it does not exist. Why? Because she can't make it fit. She can't make those injuries fit with her story. Because if she's got the knife and she's slicing at his face and she's slicing at his side and then she stabs it in the shoulder, that's a whole different ballgame. That's not a man on top of you, you reach up and you cut him. The irrefutable physical evidence is completely contradictory to the story she told. She can give you no answer for those injuries because to admit how those came about is to admit her guilt. But what about the other injuries to him? Not even just the cuts. Do we hear anything to explain why his lip is busted, why his temple has a bruise, why his chest is bruised, why his arm is bruised? You didn't hear a single word to account for every other injury on his body. Why? Because that does not fit with her story. It doesn't fit with her account. And they don't even try to explain it. You are told, you look at the physical evidence, you compare it to the testimony. And when you do that, Miss Redlick's version of events absolutely and utterly collapses. And then when you think about it, her version, her testimony is completely refuted by the physical evidence, and you step back and you look at it all and you go, it's because she's guilty. It's because she did this. And try as she might, trying to construct a story that will fit 3.5 years, and all this time, she can't do it. She came before you. She raised her right hand and she swore this was the time she was telling the truth. This was the time. This was the time for her to tell her story. When she tells that story, she leaves out significant and critical details because she's got no way. She's got no way to make it work. And so she is who she says she is. She is a person who will lie, try to influence witnesses, and do whatever she can to avoid responsibility. Today that ends.
Ladies and gentlemen, if you can turn to your jury instructions at this time, we're going to start on page 20.
All right, so the judge is going to deal with some housekeeping matters, tell this jury what they can do, what they're going to take back with them. We'll get to that in just a minute. But right now, I want to bring in my guests for this hour. Joining me, Federal Executive Clemency Attorney Tammy Allison and Deputy Public Defender for Los Angeles County, Philip Dubé. Thanks to both of you for joining me this evening. Truly appreciate it. All right, so let's begin by talking about these closing arguments, obviously. And we'll sort of start from the end backwards. We just heard rebuttal closing arguments. I thought Sean Wiggins did a fantastic job. I mean, he really harped in and honed in on the things that were strongest in his case, particularly the actions of the defendant. Philip, I'll start with you. Your thoughts on how he wrapped things up.
Oh, I thought it was pretty clean. I think he hit a home run. Yeah. I think Danielle is in a world of hurt here, to be quite honest with you. Let's assume the best case scenario for her. The best case obviously is an all-out acquittal, but on these facts, I think it's highly unlikely. I think the best she can hope for really is a lesser of manslaughter. But even then, I think she's going to have a hard time because if the jury does not believe that he tried to smother her or otherwise cause her to be asphyxiated, she didn't have the right to use deadly force. If they believe that maybe he had merely, verbally assailed her, maybe even slapped her, shoved her, you don't get to bring a knife to a shoving match. Her best hope, seriously, is a manslaughter on these facts. I thought the testimony of the daughter was devastating. I also think there may have been a missed opportunity on cross-examination, Michael, and maybe Tammy might agree with this. Because she is now 18, if Danielle is convicted, whatever estate the victim had in this case would have gone to Danielle, but then by operation of law would go to the daughter under intestacy law, or if he in fact had a will by operation of law, it would disinherit Danielle. And there's an old adage in probate law, we say where there's a will, there's a relative.
Interesting. So you're saying there might be some incentive for her to lie. Some of that came out on cross. We're going to touch on that a little bit later in the show. Tammy, your thoughts?
This rebuttal was excellent. I have to say, he really called out all of the holes in the story so that the jury could make it make sense. I thought, Michael, whenever he put his hands over his mouth to demonstrate to the jury what it would sound like, the muffled sound, whenever she, based off of her testimony, right? I think that was something that the jury is going to pay very close attention to. And I also think just the way that she pretty much lied to investigators, and that came out during the trial that she did not tell the truth. I do think that the daughter's testimony is devastating. I also think that the former Memphis Grizzlies physician who testified that he treated both of them after a domestic dispute kind of takes away of the intent with murder. So I think that if anything, what she's hoping for, that probably is going to assist the defendant in the lesser included of manslaughter.
Yeah, that's interesting. And I thought one of the strongest things that he touched on was who really looked like they were being attacked. All the injuries were on the victim in this case, not on the defendant. I thought that was pretty strong. All right, when we left off, the judge was just beginning to give final instructions to the jury before they start their deliberations. So I want to give that to you now. Let's get back into the court.
Or you have heard of recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you listen to and consider the evidence. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charge. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and I'm going to show you now what they are. You don't have those in your packet. You're going to get 3 pieces of paper as part of the exhibit. As part of the verdict. The first one says State of Florida versus Daniel Justine Redlick. It gives the case number, the division number, and the charge. And it reads, verdict as to count 1. We, the jury, find the defendant guilty of second-degree murder as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant not guilty. So say we all dated at Orlando, Orange County, Florida on this blank day of blank 2022. So this is how it looks. And what you're going to do is for one of the 3 blanks here, you're going to put a check mark or an X by what your unanimous verdict is. The foreperson will sign and date it. If you find that the defendant is guilty of second-degree murder or of manslaughter, then you must consider the special finding form and determine whether the defendant carried, displayed, used, threatened to use, or attempt to use a weapon. And so it looks pretty much the same. It'll say special finding. Answer if you find the defendant guilty of second-degree murder or manslaughter. And then there are 2 sections that you need to consider. The first one says, we, the jury, find the defendant during the commission of said offense personally did carry, display, use, threaten to use, or attempt to use a weapon. And the next consideration is, we, the jury, find the defendant during the commission of said offense personally did not carry, display, use, threaten to use, or attempt to use a weapon. So say we all dated, place for the foreperson to sign and date. For those 2 sections, you're going to select whatever your unanimous verdict is.
All right, time for a quick break. When we come back, the judge will finish up her instructions, and this jury will be given the case. So keep it right here on your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. All that can be said has been said by the attorneys in this case. Right now, the judge is speaking to the jury, giving them their last instructions before they begin deliberating in this case. So let's get right back into the courtroom as she wraps that up.
The 3rd page is the verdict form for count 2, tampering with physical evidence. And it says, we, the jury, find the defendant guilty of tampering with physical evidence as charged in the information, or we, the jury, find the defendant not guilty. And your foreperson will sign and date that. And so that will go back with the exhibits and the new evidence. So let's turn to page 24, please. Submitting the case to the jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when you all have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you have reached a verdict. You must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices in the jury room. Kindly leave those devices with the court deputy who will guard them while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in your note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. If, however, you wish to see the following exhibits, please request that in writing. Exhibit 13, video testimony of Mr. Utsi. Exhibit 14, a laptop. Exhibit 17, video testimony of Dr. Vandervelde. Exhibit 23, a second laptop. Exhibits 28 through 31, knives. And Exhibit 34, defendant's cell phone. The remaining exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Let's see. Okay. And so with that, the following jurors who are our alternates will remain seated while the other 6 go back to deliberate. Juror number 294 and juror number 309. 294 and 309, I need you to sit back and wait for me. The other 6, please take your notebooks, your jury instructions, and the deputy will escort you to the jury room. I will let you know that it's going to take us a little bit to gather the exhibits that need to go back. So you can go on and select your foreperson, take a break to refresh yourselves, and as soon as the attorneys go through the exhibits to make sure the right ones are going back, the deputy will bring the exhibits, the jury instructions, and the verdict form to you. Okay, and with that, you are excused.
All right, Judge Tanya Davis Wilson giving the case over to the jury. It's going to take a few minutes for them to begin deliberating, and always tough on those alternates who sit through all the evidence and then don't get a chance to deliberate. Let me bring in my guests. Still with me, Federal Executive Clemency Attorney Tammy Allison and Deputy Public Defender for Los Angeles County, Philip Dubé. And Tammy, I'll start with you. It sounds like both of you agree that this looks like an uphill climb for the defense. There's a lot of evidence against her, but I think there's some weaknesses that can be exploited and that were exploited by the defense. Do you see any hurdles to a guilty verdict in this case, Tammy?
You know what, Michael, I do see some hurdles there. And we talked about it a little bit earlier with the deceased daughter's testimony, as well as the former physician for the Memphis Grizzlies who treated the both of them for domestic violence. So there's a history of domestic violence between the two parties. So that would speak to her possibly defending herself, even though we haven't really seen a lot of evidence to say that that is the case here, that she was acting in self-defense, resulting in the deceased death.
Philip Dubé, you know, the prosecutor there at the beginning of his rebuttal admitted that we don't know why. We don't know why she did this. Again, they don't need motive, but they don't know why. But he tried to paint for this jury how she developed this ill will and what could have driven her to do it. Do you think they reached that so this jury knows that this was the time she decided to take this action, which seems pretty drastic?
Well, if you're going to offer up some type of motive evidence, it cannot be a might, a could, or a should. It has to be actual. And if the jury has to guess what her motive is, then they don't have a darn good reason from their standpoint as to why she would have done this. So what are you left with? Her version of events. Her version is he was suffocating her. She was defending herself from being killed. And if the jury buys it, well, that was a privileged act under Florida law. Worst case scenario, I think, would be that she acted in the heat of passion during a sudden quarrel, and that would mitigate the crime from a second-degree murder to a manslaughter. And again, the good news is it doesn't carry life in prison. I think one of the bad facts that came in, and frankly, I don't know why it came in, is this whole notion of clan endogamy, this sort of semi-incestuous backwoods hillbilly cult-like marriage that they had. I'm sure it was lawful under Florida law, but to a jury, it comes off creepy. I don't know why it came in.
Well, I mean, she was an adult when it happened. She wasn't a child. There wasn't any allegation that there was any child molestation or, you know, some people called it grooming, but she was 23 when he got married to the mother. Apparently it was a marriage of convenience, a quick thing. They went to Vegas and did it, something along that line. So that's certainly an issue, and that's maybe why it came in. But it is something that I think this jury might consider when they're considering who exactly this victim was in terms of what happened here or what happened that night. All right, guys, stand by. We do have to take a quick break. The jury has headed to the deliberation room to begin sifting through the evidence. We'll get you caught up on today's biggest moments right after the break, but right here on Court TV.
It's Brandon America.
Welcome back to Court TV Live. I'm Michael Ayala. The jury is now behind closed doors deliberating Danielle Redlick's fate. Now, if you look at our clock there, it says about 38 minutes. In just a few seconds, it'll be 38 minutes they've been deliberating. That's because throughout the day, as you guys well know, we hit the pause button so that you guys don't miss anything. So we were actually a little bit behind when we left just a few minutes ago. So they've actually been deliberating about 38 minutes now. But we do want to get right to our debrief. And for that, we bring in Court TV legal correspondent Julia Janae, and of course, she is live outside that courthouse in Orlando. All right, Julia, there was a major moment today during the state's rebuttal case, and it highlighted the Redlick's kitchen drawers through the daughter Jaden's testimony. Interesting stuff. Tell us about it.
Michael, this kitchen knife keeps coming up. Of course, it is the subject of this case, but there's something the prosecution wants this jury to be remembering now that they are in deliberations. They showed a picture, and we have it, of the actual kitchen where the altercation, according to Danielle Redlick, happened with her husband and how she described it. They were also shown the drawer where she said she pulled the knife out of. Let's first listen to how she described it when she was on the stand on direct and then on cross.
He slams me down on the counter, and I'm pinned sort of this way, and he takes his hand and he smacks my head, and so I'm just pinned up against the counter like this, and he's straddling my body here and has me pinned. And so my arm's here. I've got a free arm here, and the drawer in front of me is the only thing I can do, and I know that there's items in there. And I take the knife and I position it and face it toward him.
What does he do at that point?
He immediately just goes for my chin and pushes me back, and I stabbed him at that point. I reached up and with my right hand to pull myself up. And as I'm pulling myself up and trying to turn around, to face him, that's when he grabbed my hair and slammed my head onto the...
Slams your head into the stovetop, yes?
Yes.
He's on top of you, pressing you with all that rage and all that might, and you are, as I understand it, able to, with him on top, reach over with your left hand or right hand to locate the knife.
My right hand, that was the only free hand I had.
Now, we know Prosecutor Sean Wiggins there was really trying to hammer home this question about the drawer, and today in his rebuttal case, we understood why. He brought in the daughter of the Redlicks, Jaden Redlick, for the second time, and here's the main point of that testimony that this jury heard. And of course, we weren't allowed to show it because she was a minor at the time. The judge has prohibited us from showing it. But here's the transcript. She was shown that photo of the kitchen and asked by the prosecutor, what do you recall about those drawers on the island? And Jaden says, I don't recall those drawers ever opening or having items in them. The prosecutor asked if they were just decorative. She said yes. He asked her if she did the dishes at home. She agreed that she did, and asked if she was familiar with where the knives were kept. And Jaden said yes. And then she was shown a photo of an open drawer with kitchen utensils, a different drawer than one that's there on the island. And she said that's where the kitchen knives were kept, a point that this prosecution really wanted to make sure this jury keeps in their mind. The defense said that she really wasn't that familiar. She didn't cook in the home. She didn't even know that there were knives that were magnetic and up on the wall or splashboard of this kitchen. So they tried to downplay it, but I think a major moment for the prosecution to not only say that she was lying back then, but she's lying to you on the stand.
Yeah, that was as close to a gotcha moment as you are going to get, because not only they can't even argue that maybe they were in there. They're saying those drawers didn't even open, that they were decorative. So that's a rough one for the defense for sure. Julia, what was the jury's reaction to closing arguments? I thought everyone did a fairly decent job.
You really felt that inside of this courtroom. It's actually been very educational for people. If you think about who's been in the gallery, we've had college students who are legal interns and law students. And today I talked to some men who looked like they might have been possibly with the family because they were wearing plain clothes. They were actually attorneys from Brazil who are here looking at trials, looking at our justice system. So just interesting point about who's been in the gallery in this trial. We haven't had a lot of family that's been here seated. But as far as this jury, during closing arguments, there were moments that they seemed to be nodding along with this team, not just the prosecution, but also the defense. But I first want to play you a clip where at the end of the prosecution making this statement, there were two men who nodded along, and then also a little bit from the defense's closing argument.
He found out that his wife was talking to other men, and he reacted in quite a upset way. Is that understandable? Is it not? That's for you to decide.
We know that. Because of what she's doing 14 seconds left. Google search split English. She was not browsing a dating website while her husband is dead on the floor. The evidence clearly disproved her. That did not happen in this case. It sounds salacious. It's a great headline. It's not true.
So the first person you heard from there was Sean Wiggins. When he said, isn't that understandable that a husband would act this way when his wife has been texting another man? I saw two jurors nodding ever so slightly with him. And then once the defense was delivering their closing, Andrew Parnell there telling them about this question of the dating site and whether Danielle Redlick was looking at her Meet Mindful app while her husband was laying dead on the floor. He showed them that actually she wasn't on the app. She was in her browser. And even if she had been on it previously, that if she opened it to Google, which we know she did, to say how to slit my wrist, that even if that was open inside of her browser, though she wasn't on it, it would still look like that from the records. I saw one of the jurors writing that down. Seemed to be a bit of an aha moment. Definitely one of those headlines. He even said it was a salacious point, but just simply not something that she was doing at this moment, Michael.
And of course, the state countered that in rebuttal by saying there were actual activities on the site. So they'll have to choose between those two accounts. And Julia, what are the possible outcomes that we could get from this jury?
Well, right now, this jury has a verdict form, and what it says on it starts with, we find the defendant, there's three possibilities, either guilty of second-degree murder, the other is manslaughter, or not guilty. And of course, they also are having to determine if there was tampering with evidence. There's no lesser includeds for that one. It's just tampering with evidence or not guilty. And they also have to determine if they say that this was second-degree murder or manslaughter, whether or not it was a crime committed with a weapon. So one of those added parts of the verdict form here in Florida. Now, there are jury instructions that they'll be looking at to help them understand the difference between manslaughter and second-degree murder. And one thing to point out is they don't have to find that she intended to kill her husband for either of these. It's really a legal nuance that they have to determine the difference between these two if they say that it's not, that it was self-defense. So we have a look at manslaughter. Let's start with that one. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, which caused the death. So something that was more than negligent, closer to reckless in the way that she was acting, and resulted in someone's death. Now, second-degree murder, the state has to prove that there was an unlawful killing of Michael Reddick and an act that was imminently dangerous to another, demonstrating a depraved mind without regard for human life. In this one, you have to show a disregard for human life, not caring. They have to show that she really had a malicious heart when she was stabbing him. Even though she may not have intended or premeditated his death, they have to believe that the state has proven that she wanted to harm him in a way that really disregarded whether or not he lived or died.
Yeah, and if there's a difficult part of the state's case, I think that might be where there may be some issues with this jury. But again, we'll have to wait and see. Julia Janae, thank you so much for that report. Appreciate it. As always, let me bring back in my guest, Federal Executive Clemency Attorney Tammy Allison and Deputy Public Defender for Los Angeles County, Philip Dubé. Philip, I want to start with you because I think that is one of the areas where I think the state doubled down. They not only have the stabbing, which he argued was with ill will, and they can find that there, but then he doubled down with the fact that she chose not to call 911 and let him lay there and bleed out, even though in her mind, there was a chance that he might still be alive and could be saved. Your thoughts?
Well, I come across this issue all the time with clients, not just in the homicide context, but anytime they're up to no good, where they have no idea at the time that what they have done under the circumstances may have in fact have been lawful. So for example, when somebody acts in self-defense, they really need to consult with an attorney to find out if what they did at the time was lawful. At that moment in time, when they're using the deadly force, they're not presented with the elements of a defense. They're not presented with the elements of a crime. They're just acting under the circumstances in a way that can try to get them out of that mess. They don't know that they might be able to say something helpful to the cops, to 911 dispatch, to paramedics. They have no idea. So instead, they're just trying to cover their tracks. Unfortunately, it gives off this aura of consciousness of guilt to prosecutors and to jurors, and of course to the victim's family, if you will. The fact that she did absolutely nothing other than try to protect her own skin. But we'll see what a jury does. On another note, I cannot stand it when jurors nod with me during my closing argument, because invariably the dreaded nodders are the ones who always convict. Something happens in the jury room where they get persuaded to go the other way. They seem easily influenced during argument, and then that translates to more easy influence in the deliberation room. I dread the nodders. It's just me.
That's an interesting little point. Now, Tammy Allison, he makes a great point about what the argument was regarding what happened there between these two people and the fact that there might be some explanation. I think the defense did a fairly decent job of explaining perhaps her actions, But again, you still get bogged down in the idea that there were all these lies. It's the lies that I think ultimately might end up doing her in.
The lies, Michael. Yes, so many of the lies. And the fact that she testified, she testified in her own defense, and, the prosecutor, interjecting and trying to clarify some of the statements that she made, especially whenever she testified that her face was being slammed into the stove and which hand did she use to grab the knife. Then when we look at where the drawer was and the testimony from the victim's daughter stating that those drawers were decorative, and she never recalled there even being knives in there, that all plays into those 11 hours that she chose to wait before calling for help. And I think the jury is going to be looking at it as if she knew what she did, and that's why she was trying to tamper with some things and possibly move the knives to a different drawer to match her story, as opposed to her just being shocked from acting in self-defense.
Yeah, and again, the standard is beyond a reasonable doubt. So there's always that in a defense attorney's cap, and they're going to need it in this case. All right, they are deliberating. Deliberating clock is at about 50 minutes right now. The judge did say they will deliberate till about 8 p.m. Eastern time tonight. Coming up next, we are in verdict watch for the kitchen knife murder trial. So we asked, if you were a juror, how would you vote? We're going to hear answers coming up next right here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala. It is time now for today's Talkback segment. Each day we post a question on Court TV's social media pages. We gather your comments and questions and then respond right here on the show. We are in verdict watch for the kitchen knife murder trial. So we asked you guys, if you were a juror, how would you vote? Guilty of second-degree murder, guilty of manslaughter, or not guilty of anything at all? Still with me, Federal Executive Clemency Attorney Tammy Allison and Deputy Public Defender for Los Angeles County, Philip Dubé. All right, guys, our first comment comes from Ann. She says, manslaughter. She seems to have given up almost, and I find that more consistent with irrational behavior before and after the tragedy than tears on the stand. She does not look sympathetic on the stand, though, and I think the jury will give second-degree murder. Okay, so Ann feels like it's a manslaughter case, but she says she thinks this jury will give second-degree murder. You guys have rung in on that already. I think, Philip, you were clear. You think this might end up being a second-degree murder case. Some of my colleagues feel like manslaughter, regardless, doesn't fit this case. Your thoughts on that?
Well, I don't know that they really established enough of a heat of passion, sudden quarrel to use deadly force, right? Assuming they have, then maybe. Listen, you're asphyxiating someone, you're cutting off their airway, they can't breathe. Somehow she managed to get a big enough second wind to reach for that knife from that faux finish drawer, to stab him. And, let's be honest here, you never know what a jury is going to do. But ultimately, if a jury believes that there was a sudden quarrel or some type of heat of passion, then it would justify downgrading it to manslaughter. Now, if they decide to go with an implied malice theory of murder, it doesn't mean she had the intent to kill. It just means she committed such a dangerous act to human life and disregarded the dangers of it that the law sort of implies that intent to kill, and the jury might feel bad and feel like they have no alternative.
All right, our next comment, guys, comes from David, and he says she's changing her story, and no contemporary mention of self-defense is a guilty verdict to me. Her violent criminal history should have been admitted. That's completely relevant, especially when she was on probation for assault at the time. Defense was painting a picture of a peaceful mom. Now, he's talking about an incident she had with a police officer. That did not make it into the case, so we'll leave that off to the side. But Tammy, there's two ways that this jury could look at it and decide to let her walk, at least on the more serious charges. That's the justification that this was in fact self-defense, and there's some that could fly. There's also excusable homicide, where the killing occurs by accident, misfortune, in the heat of passion, or upon any sudden and sufficient provocation. So they could go there as well, thinking that this guy, I think the defense did a decent job of painting this victim as a little bit of a monster. I think this jury could certainly buy the fact that there may have been some aggressive behavior by him the night of this stabbing. Your thoughts on that aspect?
Michael, I think the jury can take that into consideration, that he could have been the person that even started the aggressive behavior, and she's the one that just happened to finish it because she was desperately trying to save her life. But I think a lot of the testimony that we heard coming from the prosecution was very damaging to the defense's argument that she was acting in self-defense completely, where the jury could possibly find a not guilty verdict, or the heat of passion. It kind of chips away at that whenever you think about the faux finished drawer, like Philip said, that faux finished drawer that was not there before, as the daughter of the victim testified to. So I'm not sure if it's strong enough for self-defense or for heat of passion. So the jury might come back saying that there was no doubt raised and find the defendant here guilty.
All right, well, thanks so much to Tammy Allison and Philip Dubé for being with me tonight. Always appreciate your presence and your patience tonight as well. Coming up next, we're going to review the top